All right, we're going to get started now. It's about 6:30. I usually wait a minute or two for latecomers, but I think we're going to just jump into it, and hopefully everybody who's planning to attend is here. So welcome to the Micklin Law Group's monthly webinar series. Webinar this evening is 10 things accountants should know about divorces. Quite honestly, it's I think much more than 10, but 10 just sounded good on the title. You should be looking at the screen now. The first slide should be up. You should see the title of the webinar and the law firm name. Just send a message into your chat panel on the bottom of the right side of your screen where it says questions. Just let me know if you're having any problems either seeing the webinar or hearing me. I am not seeing that there's any problems with the visual or audio, so I'm just going to jump into our presentation. Just give me 1 second to get everything situated and we'll go right ahead. So let me give you a little information about today's webinar in case it's the first time you've attended. Today's webinar is scheduled for 60 minutes. I do my best to keep it inside of that time, but I truthfully never know how long the information will take me to cover. Sometimes it's less than 60, sometimes it's more. I do have a question and answer section at the end of the webinar, and regardless of how long it takes me to get through the material, I do stay to answer any questions that may arise. This is a one-way communication, so you should see my screen that says today's webinar, and you should hear me, but I won't hear you if you speak through your microphone that's muted. But you do have a control panel. It should be on the right-hand side of your screen, and if you look down towards the middle, towards the bottom, there would be a section where it says questions. You can type in that panel while we're doing the webinar, and it doesn't interfere with the presentation, and that way you can ensure that your question's there when we get to the end in case we get into other things and you forget what the question is. We're going to be covering things now. I don't know if everybody who's registering are accountants or clients or both, or divorce clients or both. So most of the information should be known to the accountants as far as the accounting information goes. But what I'm going to try to give to everybody is considerations that you need to consider. Obviously, you consider considerations both during your divorce and after it. Sometimes the difficulty and sometimes the animosity of divorces complicates some rational thinking. Sometimes people don't really contemplate long-term decisions because they're more eager to get through and out of a divorce, that they're often just doing what they can to end it without really taking into consideration the long-term effects of some of the tax consequences of divorces. Now let me give you a little bit about me. If you don't know me or haven't worked with me, my name is Brad Micklin. This is me. I'm the managing member of the Micklin Law Group. I'm licensed to practice in New Jersey and Pennsylvania state bars and both state and federal court systems. I began my legal career as a judicial law clerk to Judge Eugene Austin, who at the time was the supervising judge of special civil litigation in Bergen County. I then went on to Kessler & Associates for a few years. I did complex commercial litigation. I left Kessler's office and opened my own practice because I found I didn't like representing companies and corporations. I like dealing with people. So I went out on my own, I think it was 2001, and briefly was a general practice attorney, which means I did a little bit of everything, but quickly learned you can't be good at everything. So I concentrated my practice into divorce, family law, and estate planning, which is what the Micklin Law Group's concentration is to date. I tend to handle more of the high conflict, high asset divorce cases, the narcissistic adversaries, which is some information that you can find on my websites and webinars I've done in the past, and essentially just high conflict litigation both in family and estate and probate courts. If you're interested in some of those topics that may come up from time to time as I go through my webinar, you can go to our website at www.micklinlawgroup.com. And there's all of our webinars are up there. We've done a lot on high conflict divorces, high conflict custody cases. We've done a few on narcissistic and borderline personality disorders and a bunch of other topics, both in family and estate litigation also, that might be helpful to you. This is just some of the awards I've received recently. I put them here not as a way to boast, but I think it's important for you, one, to know that you're listening to somebody that has some sense of what he's talking about. And if you're going to be working with me in the future, or if you happen to be working with me now, it's also good to know that other people have found my work to be advantageous to them. The ones on the left are the ones I've received most recently: American Academy of Trial Attorneys, National Association of Distinguished Counsel, top lawyers from National Advocates. The ones in the middle are ratings from organizations. Avo Rating is a website that does an independent attorney review based on a whole bunch of criteria that I actually don't even know what it is, but it is independent and it is also public. You can go to that website and read about me and my work. And the ones on the right are ones I've received actually for a number of years in a row. I haven't updated it, but Avo has provided the Excellent Rated Attorney and Martin Del Hubble the Client Distinction Award for a number of years in a row. So enough about me. Let's talk about what we're going to cover tonight. Simply, and I know the webinar is called Top 10 Things That Somebody Should Know, and there's only 5 listed here, but as I said when I introed, it's more likely to be a lot more than 10. It was just, a simpler title. So first we're going to talk about the filing status. How, whether you're filing married and separate or married and joint, single, how it affects your tax rate and your tax filings, and how to better make these choices both during and after your divorce case and throughout the negotiations. 2, we're going to talk about alimony, the considerations both of how to handle what's called pendente lite alimony, which is during your divorce case, and final alimony, which is what you agree to or is ordered after court after your case is completed. We're going to talk about child support and child care expenses, the different types of deductions that one can receive, and also how to best utilize them between both parents. 4th, we'll talk about equitable distribution, the tax aspects and tax effect of the distribution of your assets and your debts, as well as also planning. And then lastly, probably most important to most people going through this would be when and how you can deduct your attorney's fees. All right, so let's first look at the filing status. I may have some of the information backwards here, so I apologize if the slides are a little out of order. But filing status, you'll see there are several different tax rates, starting at 10% and ending down at 39.6%. The tax rate, as it says on the side, it's affected by whether you're separated and divorced. It's lower generally for married couples than it is for single individuals. The thing to consider in here is to really be familiar with the different tax rates and where they change, because of an issue that often comes up in divorce case, especially in the beginning of a divorce case that may be towards the end of a calendar year or the beginning of the calendar year when people are filing their taxes for the prior year. The tax rates during a divorce while they're still married can be very, very significant. If you look at here in the 15% rate, married joint covers between $18,000 and $73,000, but married separate, sorry for my bad circles, is up to $36,900. So this discrepancy is very significant in certain families because in a lot of cases you'll have one spouse who is the significant wage earner and then the other spouse who may not have any or very small wages. So when you get into these kinds of tax brackets where there's nearly a double amount of income to stay within the same rate, if you have a large discrepancy in incomes and one of them chooses to file married but separate, you may trigger different tax rates that, if you had better plan, would have saved taxes. But a lot of times people don't want to file joint for many reasons, which we'll discover or discuss later on. And then the second issue you need to look at is these rates right here for after filing, for when you agree to alimony. And I picked these 2 rates because this is where you will find the majority of alimony awards in your average, let's say, middle class lifestyle. And what I'm suggesting that you should look at is you go from 36.9 to 89 here, you change rates. So once you're over 36, you go from 15 to 25%. Now, if one person, let's say the wage earner, or the non-wage earner has zero income, stay-at-home parent, and gets $37,000 of alimony, and I'm just making up a number, it's not going to be very significant, but they're going to be bumped into this higher tax bracket. So let's say they're getting, again, I'm just making up rough numbers, they want $40,000 in alimony. Well, if you compute the difference between what 36 would be at 15% and what 40 would be at 25%, you might find that they're actually not getting anything. You may be able to negotiate a lower alimony number simply because the change in the brackets causes a change in loss of alimony that's more significant than what they think they're actually bargaining for. And again, a lot of clients aren't even considering the tax consequences to it. It's solid numbers to them. They're just interested in how much they're going to get. And they don't want the other person to get away with not giving what they feel they're supposed to get. But they're not usually rational, or not, I shouldn't say rational. They're usually not aware of how it can actually be affected. So now, again, there's different separate issues. I didn't want to just go through that whole tax list and take your time. If you need it, I can email it to you or it's found online. But I want to talk about some of the different aspects of the filing status. So a lot of it will be affected by the December 31st date. So if you're divorced on December 31st or before that, you're a single taxpayer. And if you're married, living in the same household, you can file jointly or separately. Now, it's not always that simple. Nothing ever is. First, to file a head of household, even if you're legally married on December 31st, you have to be, or you can be legally separated on the 31st, or you didn't live in the house for the last 6 months. Let me just get my pen going. So, legally separated, or, so you don't have to do both, or you didn't live in the home for the last 6 months. Paid more than half the cost of the house, and a child or other tax-exempt qualifying person lived in the home more than half the year. Several issues come up here. First of all, let's go back up to here where it says if married, not legally separated. That becomes a problem in New Jersey, in many places in the tax code or in tax issues, and we'll cover some tonight. Because New Jersey does not have a legal separation, but we have restraining orders which legally, physically separates the parties. And many people have contended that that is in and of itself a legal separation because by law you're forced to be physically separated. But I don't know if that's ever stood up. I actually had a client who worked in New York, filed in New York, but had his divorce in New Jersey filed that way. I never heard whether or not it was accepted or not. I don't necessarily recommend it unless your accountant says that you can do it, but it is something to keep your eye on. Now, down here we have paid half the cost of the house for the year. This is a difficult issue because sometimes it's hard to allocate. First, if you have spouses that are physically separated and you have one spouse living in the house, one out, that person may be under a pendente lite obligation, which is Latin for while the matter is pending, a temporary during a divorce alimony. Some of it may be in the nature of child support, some may be in alimony, some may be for the preservation of an asset. It's not often designated as to it's $300 for the electric bill. It may just be a $300 award, and the receiving spouse pays the electric bill. It becomes an issue for who paid more than half of the cost of the home during the year. And there's a lot of things that need to be considered here. First, in filing status overall, there's a lot of spite issues. They don't want to help the other. They don't want to cooperate. Some don't even want to talk to one another. You need to get past that issue. How to best utilize deductions, and we'll go through those a lot more in the child support and dependent deduction areas. But you need to maximize those. Support, how you allocate support, like I was saying, it could be child support, it could be alimony, it could be preservation of the asset. And you need to look at whether or not there's going to be a need to possibly amend returns that may be filed shortly before or even during a divorce case. I believe, and I apologize that I can't be certain about this, but this is what I leave to accountants. I think you can file separate, married but filing separate, and you can amend to a joint, but I don't think you can take a joint and amend it to a single. So how the parties are going to file during the divorce is significant if there's an issue that may cause them to want to change it later, like if there's tax issues, unpaid tax, underreported income issues, things like that, may be very significant. My general approach, and I'll probably say that several times through this webinar, is I try to maximize the tax benefits for both parties, although that's not always easiest to do because not everybody wants to cooperate to maximize the other person's. Timing of the divorce, filing status, timing of the divorce. First thing is, if you're contemplating a divorce near the end of the year, as I said a moment ago, if it's before the end of the year, you file single. If it's after the end of the year, actually, I'm sorry, the slide may be backwards. If you divorce before the end of the year, yeah, you can file single. If it's a divorce after the year, you can file joint for the prior year. I'm sorry, that's what the slide is saying. Now, obviously, you don't have to file a joint return. You can file married separate. Now, one issue that comes up here when there's a divorce going and one spouse doesn't want to file a joint tax return, but it may be advantageous financially, there are some cases that suggest a court can order a party to sign a joint tax return. And I've seen people, not me, but I've seen people petition a court to order it, but I've never actually seen it ordered. So I can't be certain that that's going to be enforceable. My personal thought is that it can't be, because you're forcing the party to be exposed to liability, and in some rare cases, criminal liability. So I can't see how the court would be able to do that, but I've never seen it actually be decided yet. Now, another consideration we often do, if you're divorcing near the end of the year and it is advantageous, significantly advantageous to have a joint return, you can ask the judge to divorce you on a date certain, December 10th, whatever the date may be, but hold off on issuing the paperwork until January 1 or after it. So you'll be divorced as of the 10th. You just won't have the paperwork. That's done, again, you want to maximize taxes, but people may have personal reasons that they want to be divorced. They may simply just want to because it's been so long. They may want to move on and get remarried. Most judges will cooperate with that as long as it's a genuine purpose and both parties agree with it. Some issues that you need to be concerned about when you file a joint return, obviously the less knowing spouse, or the spouse who may be sort of ignorant to the finances of the party, may be exposed to liability. Like I said, in rare cases, it can be criminal liability. There is something called the innocent spouse rule that allows you to petition the IRS to be free of liability, and this usually relates to joint tax returns during your marriage. If there were tax consequences that were avoided or income that wasn't declared, you can seek to be declared innocent spouse, not responsible. There's also something called equitable relief and separation of liability to accomplish similar aspects of what I just said. I'm not going to go into it. It's a little bit beyond the scope of this webinar, but if there are issues that you have regarding tax concerns, you do want to investigate those options. So now let's talk about the big alimony. One of the most heated, difficult issues in a divorce is alimony. And there are obviously significant tax consequences to alimony. So let's look just generally first. Gross income includes alimony payments received by the payee spouse. These are words we'll see often, payor, payee. Payee is the person who's receiving it. So essentially, that person is receiving it. It is income to that person. They will pay income tax on it. The payor spouse, the person who is paying it, deducts it in the calendar year that it was paid. It's got to meet certain conditions, which I'll talk about in a second. One important consideration here is to make sure the numbers add up. If the parties don't get along and there are concerns, maybe they pay alimony through paying a bill instead of giving them cash, and then they want to report it. If the numbers don't add up, it's going to kick out an audit from the IRS. Now, in most cases, that's not a very significant concern because it's just a question of adjusting numbers and maybe paying some taxes. But where you have people that may be self-employed, the last thing they want to do is open up any kind of tax audit. So where possible, you want to make sure the numbers match, even if there's a court order that says how much it's supposed to be. Now let's look at some of the conditions it needs to be. It cannot be designated as anything other than alimony. It can't be child support. It can't be preservation of an asset. It can't even be what we'll speak about in a minute as unallocated support. It must be called alimony. It must state somewhere that it stops after the death of the recipient. So you must ensure that that goes into any agreement that you reach, any court order that's given to you, whether it's a pendente lite order or a final one. And you must be legally separated or living in separate households. Now, again, this becomes a complicated issue. What happens when you have a two-family house and the spouses live in separate units but physically apart? I don't know. The issue's never come up. What happens when you have one spouse who moves out and maybe stays 1 week out and then 1 week in the house, or stays with the kids, or they alternate weekends? A lot of issues need to be considered, and this is why it's important that the parties be able to speak about the alimony when it comes time to tax, when it comes time to file taxes. Unallocated pendente lite support. This is a significant issue for tax allocations. The problem is, most often, pendente lite alimony is considered unallocated by the courts. They call it unallocated, which means that we don't know how much is alimony, we don't know how much is child support. Now, the court's perspective is that they don't allow the person who's paying to deduct it until later, if it's either allocated or agreed to. But the IRS considers everything that is paid as unallocated to be deductible. So the court sort of says don't take it, but the IRS says that it is. There's actually a case, it's U.S. versus Keene, Keene versus the commissioner, or commissioner versus Keene, I don't remember which order, where the IRS indicated that all alimony, if it is not allocated to be something other than alimony, is deductible as alimony in the year paid. In order to avoid this, you want to just have it determined. Put in the order or the agreement, even if it's during your litigation, that this is going to be allocated retroactively. And that's very important because the person who's paying alimony is paying a lot more if they're not getting into tax deduction, and the person receiving it is getting a lot more than they probably should be, because it should be contemplated that taxes are going to be implied or applied. If you're representing the person getting or paying alimony, you also need to factor in the potential tax consequences to them before making any agreement for temporary support. And you want to look back to the tax brackets that we talked about at the intro, because it's going to be significant as you cross over those different tax rates. Now let's look at child support and child care expenses. Child support generally is not included in gross income by the person, the payee, the person receiving it, and it's not deductible by the person paying it. If it were that simple, we would stop the slides right there, but it never is. There's many other things. There are exemptions first for children. There's a deduction allowed for a person who qualifies as having a dependent. They get a $2,000 unless otherwise provided. It's also reduced. Oh. Sorry about that. Don't know what happened there. It can be reduced if gross income exceeds a certain threshold amount, which is set forth here. I'm not going to read the whole thing out to you. I don't want to put you to sleep. But essentially, I want to make sure I got my mouse here. Hold on. All right. Sorry, I'm working with new software and hardware here. These are important because, again, these threshold amounts that you see right here are going to be important because it brings us back to the consideration of whether you're going to file married joint or married separate, as well as when you're settling your cases, you want to make agreements to who's taking the allocations or the deductions. You have to know who's going to benefit the most and least from it if they're not willing to try and agree to maximize it. And you have to watch these issues because in a divorce, a lot of people think that these deductions are significant. I can't tell you how many people fight significantly to take children as deductions. And some of them that are fighting for it aren't going to benefit much, if any, from it. Either they have too much income and they're going to be beyond the threshold, or they don't have enough where they're going to benefit from it. And it's sometimes hard to make people understand that giving away something may actually be better for them. All right, so there are several other issues about tax, child support and child care expenses. So first is the exemption is considered to go with the spouse who has custody, physical custody. Now you can trade it back and forth. There's some paperwork that you need to sign for, but essentially the IRS considers it goes to the person with custody. And the reason is that the IRS code, I believe, says that the person who pays 50% or more of the child's support, not child support, the child's support, is entitled to the deduction. And then it further goes on to say that the IRS presumes that the custodial parent is the one who, in fact, is providing more than 50% of the child's care, child's support. Now, the confusing part about this can be, at least argued, that child support in New Jersey is set by a guideline. You take a combined income and it gives you a total child care expense, and then it's divided proportionally to your income, and then you pay that. So in a case where the child support guidelines are used and the non-custodial parent has more income than the custodial parent, which is more often than not the case, that person is paying more than 50% of New Jersey's child support guidelines child support, which would then suggest that it's paying more than 50% of the child's support and therefore entitled to the deduction. Now, I'll tell you honestly, I've been arguing this for decades and never has it been accepted because they say the IRS code says it's the custodial parent. I still don't think it is, but I'm waiting for the courts to catch up with me. Now let's look at some other credits that come along, aren't often discussed much during divorce cases. American Opportunity Credit, $2,500 for the first 4 years of college. It's claimed only by the parents of the student, and it's phased out again if you're filing single and joint at different amounts right here. Again, I'm going to sound like a broken record. This brings us back to the considerations that you need to consider when you're allocating who's getting certain exemptions, and you need to look at the tax rates and the tax effect of these decisions before you can really know who's going to benefit from them. Additionally, there is a lifetime learning credit. It's got to be claimed by the taxpayer who incurred the educational expense, either the taxpayer, their spouse, or their dependent. The person must attend school at least part-time. Now I'm moving a little bit quick through these because I'm over it. Must be part-time. There's a 20% tax credit for the first $10,000. Maximum is $2,000 per household, and it phases out just like the American Opportunity Credit. Again, I hate to sound like a broken record, but these are the issues that you have to consider the phase out when you're deciding who is going to accept it in a divorce during or after it, because again, you might be fighting over something that isn't benefiting anybody. Additional issues with child support and child care expenses include when you have multiple children. A lot of people think that they split, if you have 3 children, you'll take 2 1 year, I'll take 1 year, and then we'll alternate. That's usually not the best approach. Again, I always say the spouse who gets the better use of the exemption should take it. What I usually suggest is that you find out what each parent would get by taking the deductions. You see what the numbers are. The numbers are significantly higher by letting one parent take all of it. You split the difference, or you give the other parent what they would have got by taking it, and let the parent with the higher exemption keep the balance because somebody would have gotten nothing by taking all of it. The other person, meaning, would have gotten nothing if one person takes all of it. Here, everybody can benefit. Next is the child care credit. This is a unique issue because you get a credit for 20 to 35% of work-related child care. Here are the maximum and minimum numbers underneath it. It's only available to a custodial parent. The issue becomes, and this issue is often important in child support matters during a divorce case, so it may then spill over to afterwards tax consideration, and that is what's work-related child care. Child care is, first of all, it's got to be work-related. So if you have a person who's not working but is seeking employment, they may need child care during the day so that they're free to interview or free to look at ads. So that's one issue you have to look at. Second is it an approved facility? For the guideline purposes, New Jersey child support guideline purposes, it has to be through an approved daycare agency. So you can't have grandma at home doing it. But the consideration and the concern is sometimes grandma is a hell of a lot cheaper than a daycare facility is going to be. So while you may lose the tax credit, and it may also adjust your child support negatively, you may save significantly by doing something less formal than work-related childcare. And most of the time, judges will allow you to agree to sharing like a child support credit, even if it's not work-related, because they know the cost of daycare, at least up in North Jersey, is exceptionally high. And the more children you have, the more difficult it can be. Moving along to a similar issue is day camp. Some companies offer a dependent care reimbursement account for that. Not too common. The issue I raise here to consider is, in many cases, day camp is actually a form of daycare. The children aren't going to camp because they want to broaden their horizons. They're going to camp because mom and dad are working and they can't leave the kids home during the day. So you need to talk to your account about what can be taken of your day camp expenses as work-related childcare if you don't hit the maximum under work-related daycare. All right, let's turn to another big issue in divorce cases, equitable distribution. That is the distribution of your assets and debts. Real quick, most people erroneously believe it's 50-50. It is not. That would be equal distribution. Equitable distribution means it's based on what's fair. Now, that's obviously a strange term because what one person thinks is fair is not what the other person thinks, and certainly not what a judge is going to think. But that's how we're supposed to do it. There are a number of statutory concerns or considerations that are given to make that decision, but not part of this webinar. I digress. So generally, there's no tax consequence to distribution of assets or debts between spouses. And then also between former spouses incident to a divorce. And that's there because the actual transfer of the asset often occurs after the divorce. So it's either between spouses if you're doing it during your divorce, if it's after, but within 1 year. Very important, 1 year, because a lot of things don't get done that quickly. Divorces get signed, paperwork gets filed, people move on, they have new relationships, they may have new children. Things like pensions and retirement accounts often take a lot of paperwork. Houses aren't always sold quickly and things like that. If it's after 1 year and you're transferring deed or you're rolling over a retirement account or a cash asset, there could be significant tax consequences. So you need to make sure that you or your lawyers are on top of this and that everything is done expeditiously. So when the transfer is treated as a gift, which is why it's not taxed, but an important thing that you have to understand is that when you receive a gift, you're receiving what's called the transferor's basis, which means you're getting the asset at what the person who got it bought it for. So if somebody bought a house in 1910 for $4,000 and they give it to you in 2016 and it's worth $700,000, if they give it to you as a gift or you get it in a divorce, you're going to have a significant capital gain tax when you sell it. So most of the time, currently, it's not that significant. The average divorcing couple is in their mid to late 40s. Housing prices they bought when they were elevated. Not many people are divorcing after 80 years. I mean, look, there are some who do 50, 60 years. It's rare. So the bases haven't changed that much for property as much as you'll see when maybe a grandparent leaves a house to a grandchild. But there are times where there are significant concerns. Somebody may have inherited the house, which is generally an exempt asset, but let's say for some reason it's not. They got their house, they bought their house from their parents when they got divorced, and parents gave it to them, for $1, but the parents bought it in 1910 or whatever. So if that's being divided in divorce, there's going to be significant tax consequences because the value of that is going to be so low to the person who's receiving it in the divorce. So the thing that you or your accountant needs to do, or your attorney, is to be sure to find out the basis of all the property in your divorce before you agree to distribute it. Because if there is going to be future tax consequences to it, you need to factor that into it. And that is mostly important for tangible assets as opposed to retirement accounts, which we'll talk about in a second. Tangible assets like houses, stock accounts, which is not necessarily tangible, but often have significant changes in basis from purchase if they're held long-term to sale. And it's very important that you document it. Retirement accounts, qualified retirement accounts don't have that same rule. They're governed more by either federal code or federal law. More often than not, the simple way to understand a qualified retirement account tax issue is if it's being rolled over into either a similar type of account, like one IRA to another IRA, or if you're going to do a qualified domestic relations order, often referred to as a quadro, there will be no tax consequence to it. There will be a tax consequence, significant, if you withdraw it. So let's say one spouse has a 401k and they want to take it out as opposed to rolling it over to another 401k or an IRA. You're going to pay taxes. You're going to pay income tax. You're also going to pay probably some kind of penalties. So you may lose close to up to 50% sometimes of the money's being taken out. So again, before doing this, speak to your accountant and find out what the tax consequences and penalties will be if you're going to take a direct pay or withdrawal as opposed to rolling over retirement accounts. Houses, another significant asset that are transferred inside of divorces. Generally, what this slide is showing or saying is that if you own the house and you've lived in it for 2 out of the last 5 years, if you profit $250,000 by yourself or less by selling it, you won't be taxed. If you sell it around the same terms but in a joint return and you make $500,000 or less, you won't be taxed. The issue is, for a lot of people going to divorce, they think if they leave the house, are they losing their interest in it, or are they abandoning it? That's never the case. The only consideration you need to have with a marital home is that you've lived in it 2 out of the last 5 years, which is important because a lot of people separate long before they divorce. So if they weren't there for the last 2 out of 5 years and then they take it into the divorce, they may not be able to exempt the $250,000 gain that most average people can. Need to understand the timing of that and the relationship to the parties. Like I said, because a lot of times they'll be separated for years and years, and the lawyers and accountants may not know that. So let's see any tax implications, even where there's a tax-free transfer rule applies. Appreciation of an asset will always lead to potential tax gains. So while you can't really contemplate or you can't really plan for income or appreciation, it is something that you need to consider. Are you gaining something that isn't a volatile market? Are you getting something that is projected to be significantly more valuable in the future than it is now? Did you do massive improvements or you plan massive improvements? Things like this will significantly change the value and therefore the tax later. It's also important because a lot of people in a divorce will do things like, I keep the house and you keep your pension plan. And they're never looking at the basis, which in turn leads you to what would be the capital gain. And here you can have almost 20% tax on a capital gain. So if you sell a house, if you take a house in lieu of a pension rollover and there's a capital gain on the house, if you sell, first of all, I don't like that because you can't really eat a house. You can't liquidate a house quickly. But if you do, if you're losing 20% where you would have had this in a pension rollover, or the amounts were not equal, the values were not equal, then you're really not getting an equal or an equitable transfer of your assets. Here is just a quick example. I'm not going to go through it. It really just illustrates what I'm talking about, but I think I'm a little over time, so I want to make sure to be as close to the end as possible so I don't keep anybody much longer than I mentioned in the beginning. So deduction of attorney's fees, probably one of the people's views as one of the worst things of a divorce. I was going to say the worst, I mean it's not, but people feel often that it is. Generally, it's useful to negotiate the payment of fees in a global resolution because you generally won't be able to deduct attorney's fees. The general rule, at least, is that you can't deduct them. There are exceptions. They're sort of complicated. I'm going to run through them for you, but they're generally related to fees related to the production of income can be deductible on your personal income taxes up to a certain point, which we'll try to cover as we go through this. And real quickly, their production of income, alimony, qualified retirement accounts, and protecting capital assets. Let's look a little bit at these. One point I want to give you. I do this, and I recommend that anybody using other attorneys, ask them for this specific billing is needed to take advantage of this. Meaning, a lot of attorneys will send you a bill that says letter to client, telephone call to client, email to adversary, and they don't really describe what it is. You're never going to be able to support a deduction of attorney's fees unless it says telephone call regarding alimony, tax meeting to discuss pension rollover. It's got to describe what it is, because it's got to be able to be linked to something related to the production of income. So, and don't wait until after your case is over to have that done, because it's almost impossible to go back over invoices and to allocate exactly what they are. Our invoices are always detailed to what exactly is being done so that you can use them later. You should bring them to your accountants. Again, it is complex. That's what I was just saying. So we'll move right in. Alimony. This applies to both divorce and post-judgment, like the pendente light I was talking about, and post-judgment. Only for the paying spouse, only for the person receiving it. Unfair, but that's how it is. The person receiving alimony is able to deduct a certain portion, may be able to deduct a certain portion of legal fees attributed to the receipt of that alimony or that award. May even go towards motions later for enforcement, which is a very common post-judgment application. I recommend each year you talk to your accountant to see if they believe that any of the fees paid in the prior year are deductible for tax purposes. Every year you may, some cases, have fees, unfortunately, every year for one reason or another. Let's look at qualified retirement plans. Fees incurred, again, can be deductible. They're taxable to the alternate payee. Distributions are taxable to the alternate payee. The alternate payee, and this is again subject to the quadro we were talking about, qualified domestic relations order. Distributions to the alternate payee, that is the person who is not the employer. So the person receiving the distributions from a qualified retirement plan may be taxed on that. So you may be able to deduct some of the fees incurred in obtaining that or enforcing it, for instance. Again, check with your accountant, but it may be a good way to offset the tax that you receive or that you may receive. Here is why you need to talk to your accountant. They're treated as a miscellaneous itemized deduction only to the extent they exceed 2% of your adjusted gross income, and then it phases out when your adjusted gross income exceeds a certain amount. It's far too complicated for me to take the time to do that analysis with you now. It's something you definitely want to talk to your accountant. I can say simply that more often than not, the phase out of the adjusted gross income prohibits most people, prevents most people from actually being able to benefit from it. But don't take that as not important enough to look into. You definitely should. And the last, I think, we're talking about protecting capital assets. Professional fees incurred to protect capital asset may be added to the tax base of the property. What this means is, when I was talking before about the basis, you have to be aware of the basis you get, because that is the cost of the person who got it that's giving it to you as a gift. So if I bought a house in 1910 for $4,000, my basis is $4,000. If I give it to you now and it's worth $700,000, you still get the basis at $4,000. You'll be taxed up to nearly 20% on it. Reducing your capital gains by deducting some of the fees incurred to obtain it will at least soften the blow a bit. Gilmore versus the United States is just a case that talks about this deductibility issue. There's a few closing points to make on alimony, additional alimony. Again, these are points that I pretty much covered throughout most of this. I don't like to repeat myself, but you need to talk to your tax accountant. You need to look at the different deductions of child support and you need to specifically be aware of the alimony and the tax rates. You may need to have additional alimony ordered to adjust the rates. You may have somebody, the paying spouse may be in such a high tax bracket, paying more alimony may actually bring them into a lower tax bracket. So that person may want to pay what we call additional alimony than they're required to because they're actually saving money. And the lower earning spouse won't be harmed, so they're getting more. The net is the same. But a lot of people, especially when it comes to things like alimony, they can't see that. They can't see paying more can actually be good for them. So you really need to plan it, and you need to talk to your accountant. Now, I'm going to take a second. I'm going to go through a couple polls. Actually, I'm going to wait. We have a poll to ask you some questions to see what you think of the webinar. But first, let me see if we have any questions. I think that, yeah, that was the last slide. Let me see. Let me open up real quick. All right, there's a question. But the tax rate only applies to the amount of the. All right, there's a. I don't know if it's a question or a statement. It says, but the tax rate only applies to the amount over the cutoff of the previous bracket, not to the whole amount. Probably typed while I was saying something. I'm assuming this is an accountant who's just correcting me or adding to my information. I'm not really sure if that's just for the audience's benefit or a question. Again, and maybe this person wasn't signed on when I started. The whole point of my webinar was to show I'm not an accountant. I don't give tax advice beyond the limited scope of the issues like I discussed here. The point of today is for the client to know what to ask their accountant for. It's also for the accountant to know what the considerations that the client should be having. It's not always about just, okay, you get alimony, you take the deduction. He gets the children, he takes that deduction. You may need to investigate if that was the case and if that's the best case, because an agreement can always be modified afterwards. Even in a judgment can always be modified afterwards also by an agreement. An agreement, now it's got to be in writing. I've had people make the horrible mistake of thinking that because they're getting along, they can do things without in writing. That's good when you are getting along, but you may later not be getting along, so always put it into writing. But I hope that I was clear through this webinar that these are just things that I see through divorces that I think clients need to bring to their accountants, and accountants really need to bring to their practice. I don't see any other questions. Feel free to type them in the next moment or two. I'm going to launch a couple polls just to get some feedback, if you don't mind hanging on for another few minutes with me. All right, you should see the first poll up there now. All right, so it shows social media is popular results. Okay, we just got a couple more for you. Okay, good to know that this time works for people. I'm sorry for not saying this before, but your answers are never displayed or provided to anybody. They just come to me. What I put up here is just your results, but nobody knows that you were even attending, let alone what you're responding to. All right, so it looks like we got 50-50 as far as accountants here. By the way, for those accountants, if any of them have tips for me in ways that I can improve my practice, I'm certainly welcome to the. Oh, very good to know. And I believe this is the last one. All right, I thank you for attending this month's webinar. Our webinars are almost every month on the last Thursday of the month at 6:30. From time to time, holidays and things like that come up to complicate the schedule, and dates may be changed, but they're generally going to be a Thursday and most often the last one. I'm going to take one more second, see if any other questions pop up before signing off. Okay, I don't see any, so I wish everybody a good night, and hopefully I will see you at the next webinar. Good night.